asked interested party. Let the record of this honorable court show that we were not given an opportunity to be heard on the issue of consolidation. And the record shows the court has acted of its own volition in the normal practice, even under the Matunga rules, to accord parties to state their views on proposed consultation. This is a constitutional issue. We were not asked to do it. Thank you.
Your Lordship, we have had the order that has been granted by the court, consolidating the matters and creating another lead file. And that creates the problem you are trying to address in the morning, Your Lordship said. That now this bench has created 2 lead files. We have 6 files that are before you, Your Lordships, with the lead file being E522. Which files are not before you? We have now created another lead file, E565. Your Lordship, those are some of the issues we were trying to raise in the morning. That if those other files were before you, this confusion would not be rising.
Mr. Ndegwa, there's absolutely no confusion in these matters. Let us not bring confusions where there's none. I think in terms of consolidation, we have cited the rule under which we have acted, Rule 17 for avoidance of doubt of the Mutunga rules. I think we need to move forward.
Yeah, and my lords, on behalf of the respondents, we confirm that we are ready to move forward. I think too much time has already been taken on issues that are not very fast. Save, we would like to make 2 proposals. First, we would like, my lord, having read what has been filed by our colleagues this afternoon, we would like to propose that their application for recusal and this application questioning how the panel was put together should be had together, for the very simple reason that they rely on the same set of arguments and facts. And I draw your attention to paragraph 5. They say that the impartiality of this court, the one we are before, has been questioned. And at the end of their prayers, they say that it is therefore in the interest of justice that this honorable court recuse itself. It would be gravely injurious to the respondents if they were allowed to prosecute this application, take one bite at attacking the court, and however the court rules, bring the other application for recusal and take a second bite. We would like to argue both of them together. Secondly, we would like an allocation of time, because it is quite clear to us that in the absence of directions allocating time, we are going to have another long afternoon of long, winded speeches that do not address the specific issues. We are willing to say in advance that whatever time you give us, if you give 10 minutes each, we shall accept. If you give 15 minutes each, we will accept.
Have we cited the applications? Have we cited the applications? Have we not seen the applications? 601. Professor Githu, which applications have been filed? How many applications?
The one you directed, my lord, in the morning.
Yes.
Yes. But it is in that application that has been filed by Jindo Matiba and company advocates. That is the application that seeks, on the one hand, that questions how this bench was appointed, and on the second hand, it requires the recusal of this bench.
So for avoidance of doubt, it is one application.
It is one application.
There are 3 applications.
But there is an earlier application for recusal. And that's why I'm saying we probably can hear both of them together.
Yes?
I'm sorry, my lord, my lordships and my lady, I just wanted to remind the court of Article 159 of the Constitution. In exercising judicial authority, the courts and tribunals shall be guided by the following principles. And 159(2)b, justice shall not be delayed. So I'm requesting my lordships and my lady to kindly refer to that provisions and let us move forward. Thank you.
My lord, let it come on record that this is the first time in which, on a matter of extreme national importance, we've been given 1 hour to be able to do an application, serve it, and come back to court. We have tried to do the best that we could in terms of complying with those directions. Then, of course, one of the issues that we could not be able to do is that the written application could not be able to do full justice to the instructions that we've been given and to our case. And therefore, my lord, when Professor Gebu Muigai stands senior counsel to say that we need to be gagged on the issue of time, we protest. We shall require sufficient time. This sufficient time is not forever. This sufficient time, at least for purposes of the 3 presenting the that application, is 1 hour. It is the least that people deserve in an application of this nature. Second issue, my lord, is the issues of consolidations. Those issues of consolidation are as different as UDA can be from Jubilee. And the issue is, for purposes of the difference, the application under Article 165, and we did not hear you talk about the inclusions, because we've had to include. Their earlier complaint in the morning.
Lord, I'm sorry to say this.
I have.
Yes, I want to interject. If my learned friend is appealing against your orders, then there is the right forum.
There is no order.
My lords and my lady take charge.
There is no, I'm responding to what has happened. Let us be fair to each other. And my lord, what I'm saying is this, that for purposes of those applications, the application under Article 165, because in the morning when we raised the issue orally, the questions that was raised, you are raising issues against the Deputy Chief Justice, who is not a party. She is a party now, and we have served her. We do the application on the issues of the constitutional violations regarding the empanelment of this bench. We shall need the court's directions on that issue. And we've gone through the authorities within the short period that we were here. So we are standing on solid grounds. We just need sufficient time to do our business. Issue number 2, my lord, if that applications were to succeed, then it would effectively mean, as my learned colleague Mr. Ngoya had indicated, then the issue of recusal of your lordships becomes academic. But if your lordships were to hold that all these serious injustices that the petitioners alleged were committed by the Deputy Chief Justice are okay, then we shall now address you, the issues that concerns you. And I need to add, on the issues of authorities, because now we've been told different instructions. Well, when we came here, we thought that while we were proceeding and taking directions, prepare the team in the office, let them prepare authorities to argue on the issue of recusal. When we were given 1 hour, we told them, oh, stop on the issues of recusal, now we are dealing with another thing. So, my lord, we cannot be able to argue, if it is today, we cannot be able to argue, as expected by our client, on the question of recusal. And there is no similarity of issues. Therefore, my Lord, I urge you that let us adopt fair procedure. This fair procedure has always been there. There are 2 applications.
Where are they? Yeah, 3 applications.
At least I know, Lego will mention one.
Yeah.
We are actually bringing them even, one of them in number 015 is an application dated, I believe, yesterday, 21st of October. There is another one. The other one, Legua. Yes, my Lord.
E0. We'll deal with the application before us.
My Lord, may I please you?
The application for empanelment is mentioned.
Where's that one? Where's the application? Where's the application? Empanelment.
Yes.
And perhaps, my Lord, before you give the directions, with my Lord, Ms. Kimotho, she's informing me that she was not aware of directions in the morning, that applications be filed and we come back before you. And now her petition has been integrated in the consolidated petition. That is petition number E013. Therefore, she's not been able to file an application either for recusal or for challenging the empanelment. She was just requesting if she can be served with those applications and the responses, and she be given time, 1 hour just like the others, to file her similar application if she so wishes. Because now she's participating in a proceeding, she did not directions.
Council, listen to this and listen to this very carefully. All of us acknowledge
The momentous import of the proceedings before us. And all of us are enjoined by the rules of natural justice to do what is right. This bench is not going to be taken round in circles. We will not be taken round in circles. We are here to do justice for the petitioners, justice for the respondents. And anything which is intended to delay these proceedings will not be acceptable because both parties have come to this court under certificate of urgency. Let us be very careful how we argue our matters. We want everybody before us to get justice. That justice will not be possible if every advocate who stands up wants to take the cause in cycle. We will not allow that. I'm making final directions on this matter. The matter which we are dealing with is an application dated 22nd of October 2024 by Jindo Matiba and Company Advocates. It seeks